our next speaker, Brian McGarry, is going to touch on some of those issues with respect to the cost efficiency in state-to-state dispute resolution and perhaps efficacy as well. Thanks. Brian, it's yours.
Thank you, Jansen. That was an exceptionally smooth transition. Thank you very much. It's great to be here. Thank you all for having me today. A lot of what I had planned to say follows and dovetails very nicely with what Stephen had discussed in his excellent presentation. I, in fact, have the unfortunate task of sitting on a table with individuals who can tell you very engaging war stories from the trenches of interstate dispute settlement, and I am here to regale you in the riveting stories of grant applications. But I'm going to take this extremely seriously because this particular detail of dispute settlement, while banal, is by no means trivial. In fact, at the heart of it, rising dispute settlement costs entail an issue of access to justice. And developing states, subject to economic or military crisis, may be more vulnerable to higher volumes of claims in both interstate dispute settlement and mixed arbitration. And the limitation of funding resources may therefore correlate to the relative strengths and weaknesses of the state's ability to actually bring the case forcefully in each of those instances. So while cost-saving measures have taken on systemic importance to parties and institutions and international dispute settlement writ large, involving private parties as well, they have surfaced in perhaps more varied ways in state-to-state dispute resolution to overcome this when sovereign concerns are at stake. And we can identify three such paths, which is the first and last slide in my presentation. What I've tried to do is to take, from a practitioner's standpoint, all of the different ways in which your client, as a small state or a developing state, or as I'm going to focus, a small developing state, may wish to control either unilaterally or bilaterally or otherwise the rising costs in an interstate proceeding. And the first of these that I'm going to spend the most time on is reducing the overall costs through institutional funds in interstate dispute settlement. State-to-state dispute resolution institutions, such as Stephen has already indicated, the ICJ, the International Tribunal for the Law of the Sea in Hamburg, as well as the Permanent Court of Arbitration, have each established trust funds for dispersing grants to applicant states on an ad hoc basis, and thus mitigating the overall cost of arbitration. So my discussion on this point is going to focus on the extent to which the different regulations which govern these three mechanisms have impacted the utilization of each forum. Now, small states, as a terminological issue, of course, aren't all developing, but some states which do meet that cutoff of less than 1.5 million people are, in fact, appearances on the OECD DAC list, which we could consider to be a good benchmark for reasons which will be indicated later. And in fact, as Stephen indicated, have substantial and significant practice before these bodies. At the ICJ, he mentioned the Marshall Islands. Timor-Leste also had a case there, as well as Nauru, Dominica, Djibouti, and Guinea-Bissau. At ITLOS, surprisingly, a fair amount of practice there as well from small states, which are in fact developing states, largely due to the use of flags of convenience in those states. Seychelles, St. Vincent and Grenadines, and Belize. And at the PCA, an ongoing case involving Sao Tome and Principe, a famous arbitration involving Guyana, as well as was indicated by Stephen, Mauritius, and again, Timor-Leste. Other relevant angles here, because as we've discussed already, dispute settlement between states is not simply a matter of adjudication or arbitration. We've seen successful mediations and conciliation processes under the auspices of the UN involving now one beginning with Timor-Leste, as well as in the past Gabon, Equatorial Guinea. And potentially, we may one day see certain states like Kiribati and the Maldives break a new trend of climate change litigation, even if only as many of the Marshall Islands cases a couple years ago were initiated as under a forum prorogatum basis, essentially as a public relations campaign. So I'm going to focus on the ICJ, ITLOS, and PCA, keeping in mind this broader perspective on the role of interstate dispute settlement and the need to make it more not just effective, but cost effective. So at the ICJ, there is the UN Secretary General's Trust Fund to assist states in the settlement of disputes. This was established in 1989 to encourage states to submit their disputes to the court, quite evidently. This is inherently restricted to the party's representational cost, as the ICJ's budget is covered by the UN General Operating Budget. And this is available to states in all circumstances where the jurisdiction of the court or admissibility of the application is not or is no longer the subject of a dispute on their part. So it is a bit of a give and take. You cannot obtain the funds to settle your dispute before the ICJ if you are going to, with the other hand, attempt to challenge the court's jurisdiction. This is also available to help state parties not only during the dispute settlement process, but also in compliance with judgments, which has had substantial practice, such as when you have a boundary delimitation judgment that needs to, if it has to have any meaning, to be effectively demarcated on the ground using technical experts and perhaps, again, lawyers. So while this is expressly a voluntary fund, it has been somewhat opaque as to non-state contributions. For example, as of 2011, the fund had less than $1 million in it, US dollars. The report the following year, 2012, noted that states had contributed only $40,000, yet the total then on reserve had tripled to $3 million, no explanation given. The trust fund's terms of reference require itemized statement of estimated costs when you are applying on behalf of the state, and an undertaking to, when all is said and done and the case is concluded, provide a full audit and reimburse as necessary. Now, the Secretary General, each time he receives an application, assembles an ad hoc panel of experts, which in each instance, quote, shall be guided solely by the financial needs of the requesting state and the availability of funds. So it is a proportional balance that does not expressly take into account whether or not the state is, for example, a least developed country, but certainly does take it into account implicitly. The original terms of reference, as established in 1989, very critically limited the availability of dispute settlement funds to those cases which were submitted by compromis, by special agreement. And the rationale was to avoid accusations of partiality in cases that involved, as we said, jurisdictional objections. But this has been applied mutatis mutandis, for example, in the case between Guinea-Bissau and Senegal, because jurisdiction was no longer contested by Senegal, the respondent in that case, at the time that Guinea-Bissau made the application. Now, this fund came on the heels of the Secretary General using his good offices to obtain funds from Switzerland at the request of Burkina Faso and Mali in the 1980s to defray demarcation costs associated with implementing the court's 1986 judgment between them. So it was a good idea at the time, as we say, and we're going to see how it has or has not worked out. The early grants after its establishment in 1989 included either Guinea-Bissau or Senegal, it's not clear in the report, which received money to defray the printing and translation of documents. In a subsequent case involving Chad, we know that Chad was the recipient of funds for the same purpose because the agent of Chad in the hearing expressly acknowledged and thanked on this point. There were two later grants for parties in boundary disputes to defray the cost of counsel, experts, printing, and indeed prospective demarcation costs, which were estimated in advance. And in a 2004 joint application by Benin and Niger, each of them received what was then a far greater sum than had ever been awarded before, $350,000 US dollars for each of them. Now, the perceived underutilization in 2004 of the use of the fund over the last 15 years led to the revision of those terms of reference, which allowed, as it is now, any state, regardless of the basis of jurisdiction, to lodge an application before the trust fund. So, as well as cases, for example, submitted pursuant to a compromissory clause, as you find in UNCLOS, or pursuant to the state's optional clause declarations pursuant to the ICJ statute. But the procedure nevertheless remained laborious, and participants with firsthand experience of this at a 1997 gathering established by the Project on International Courts and Tribunals observed significant delay in obtaining funds. President Guillaume of the ICJ, while he was presiding, asked the UN General Assembly in 2000 to streamline this process, noting one instance in where a state was awarded funds but did not actually take them because of the complexity of the procedures involved. So the UN did not accept this plea to streamline the process, and what we see is essentially a trust fund which is vastly underutilized. It has only resulted in 2 subsequent applications since that revision in 2004. 300,000 went to Djibouti in its case with France, which had consented to jurisdiction at that time. And in 2014, to put this in perspective, Burkina Faso and Niger, following their boundary judgment, jointly applied for funds regarding the demarcation of that judgment. That was in 2014. By the report issued last year in 2015, the case was still under review by the Secretary General's panel of experts, and we'll see when the 2016 report comes out whether 2 years was a sufficient amount of time to determine whether they deserved funding from what currently has approximately $3 million sitting unused. Now, the ITLOS Trust Fund bears very little reference in this state. It was established in 2000 by the UN General Assembly resolution at the behest of the United Kingdom. And this makes express reference to the ICJ Trust Fund's mandate and uses the same expert panel approach. But very importantly, it permits grants for jurisdictional phases in cases and exceptional cases. And it permits grants for the preparation of cases, unlike the ICJ. So if a state or 2 states are considering possibly adjudicating their dispute peacefully through one of these mechanisms, they can get funding from ITLOS. They cannot get it in advance from the ICJ. The only application lodged before ITLOS was by Guinea-Bissau as a respondent to St. Vincent and the Grenadines in the Juno Trader case. That resulted in a $20,000 award, which was approved in 2005 for Guinea-Bissau. Guinea-Bissau never took that money. The case had long since ended at that point. This was a prompt release case. Most of the cases at ITLOS deal with provisional measures or prompt release. There's a sense of urgency. So the staggeringly low sum which was awarded in that particular instance, thank you, is probably not the only reason why this system is ill-suited to ITLOS, a body which is given toward urgent cases. The case has long since been settled by the time the money comes through. Finally, the PCA's Financial Assistance Fund was established in 1995 by the Administrative Council with a similar voluntary donor basis as the ICJ, but it has some very important distinctions. This includes not only party costs and implementation, but also tribunal fees and registry costs, which you don't have to deal with before the ICJ or the ITLOS because those are funded by general budget of member states. In order to apply for funding from the PCA's fund, you must be a state or a state entity. You must have acceded to one of the founding conventions of the PCA, and you must be on that aforementioned OECD DAC list. This is open not just to arbitration, but conciliation and other dispute settlement processes. It's open to states as in ITLOS who are simply contemplating dispute settlement at the time. And unlike ICJ and ITLOS, it does not have the ad hoc appointment of new members of experts to review each application. It has a rotating board of trustees, which currently includes 3 former ICJ justices, Yves Fortier and Professor El Kosheri. Most importantly, there is clearly no jurisdictional bar. You can request funds in instances where jurisdiction is contested. In fact, the first grant in 1996 went to an African state which was responding to an investor state dispute settlement case at the PCA to supplement the costs of hearings on jurisdiction. And the PCA's track record has been, let's say, equivalent to the ICJ in terms of recruiting funding and actually receiving requests for it. It is all three mechanisms are vastly underutilized and underfunded. We can leave off on this by making reference, this is appropriate since we're at WilmerHale, to the Abier case, which was not interstate, but which was in fact enabled by recourse to the PCA's Financial Assistance Fund. That was one very important aspect of how the case was able to go forward. Another very important aspect of the case will bring us to the second point here, which I'll briefly touch on, which is the reduction of legal fees internally or through third parties. In that case, the fact that the Financial Assistance Fund from the PCA had managed to get together enough ad hoc donations to support the party's costs was not itself sufficient. It was also dramatically enabled by the fact that WilmerHale, as well as the PILPG, essentially rendered millions of dollars worth of legal services pro bono. So when we speak of third parties, we can speak of this in a variety of different ways. There is, as I just mentioned, the reliance on pro bono or heavily discounted lawyers. Probably the best example of this would be in the WTO framework, where the Advisory Center for WTO Law, definitely the smallest intergovernmental organization in Geneva, has an excellent system that focuses not on what we just discussed, which is subsidizing litigation, but rather on strengthening lawyering capacity. And it does this most directly by making itself available to all developing and transitional economies, but particularly focused on least developed states, in order to, at a dramatically reduced rate, counsel them on their live WTO disputes. Other types of third-party funders, what about private sources? Well, we can think of philanthropies such as the Bloomberg Foundation's support for Uruguay and its tobacco-related investor state case. One can very easily see that happening in a WTO context as well. Industry, private industry players may serve a third-party funding role for these states who are involved in boundary cases, where there may be, for example, seabed resources at stake, and energy a company with a relationship with one of those states may have an inherently vested interest in ensuring the certainty of those borders and therefore mitigating any investment risk. With that in mind, I'm going to turn to the last aspect, which is reducing operational expenses through the mutual agreement of the parties. And you can think of this in two different ways. One is party controls, which are common to all forms of arbitration, including private parties and mixed arbitrations, simply by adjusting the terms of reference in the many different ways in which costs can be minimized in advance by thoughtful lawyers working on behalf of their clients. But in the state-to-state framework, there is a second, more nuanced aspect that we can look at, which is the general trend in state-to-state arbitration, which is for each state to bear its own costs and half the arbitral tribunal's costs, as we've seen in many cases. Exceptions to that being the aforementioned ABIICL case. The PCA also administered a confidential case involving an intergovernmental organization in multiple states, which were all members of that governmental organization. In that sort of instance, we've also seen deviation from that general trend to have all parties bear their own costs. But other particular nuances in state-to-state frameworks may include the high sensitivity to the role of tribunal experts, which would otherwise save money rather than reliance solely on party-appointed experts. A mutatis mutandis deviation from treaty-prescribed procedures, such as in the UNCLOS annex concerning arbitration. It stipulates in the treaty that there is a 5-member tribunal. We have a case right now that we can observe at the PCA between Malta and Sao Tome that is under that treaty, but is a 3-member tribunal. It is the creative mutatis mutandis application with the consent of the tribunal. And finally, the last nuance in state-to-state frameworks that I'll speak of is perhaps the most obvious, which is the fact that unlike mixed arbitrations and private commercial arbitration, there is a prevalence of peace and security issues and urgency. We saw that in ABIICL, where we had a fast-track 9-month arbitration from constitution of the tribunal to the rendering of the award. In that case as well, there were costs associated with transparency, the full publication of the award with open and webcast proceedings, and another instance that you don't see in private arbitration, which is security costs, UN peacekeepers on the ground during the award ceremony. So in conclusion, when I was preparing this, Jansen asked me to make sure that I point out whether I have a view on the efficacy of these various procedures rather than simply informing you of these various details. And if you can guess, my view is not entirely positive. All of the trust funds that I've mentioned need to be much more systemic, with less of an ad hoc approach. One could see this changing rather than voluntary contributions to a general budget situation where a slice of every member state's contribution to, let's say, the UN general budget goes toward the trust fund rather than relying on ad hoc contributions. Now, why would a state such as, let's say, the United States want to support this? Well, any large state with a robust foreign policy is going to see the general interest that they have in developing states and small states settling their disputes peacefully under the rule of law. That is not synonymous with the fundamental point that Stephen made, which is jurisdiction. So one can contribute to this without fear of being attacked as a result of it. And ultimately, I think that's in the interest of many states. With respect to the ad hoc system that prevails in the trust funds, it also seems to me to raise appearance of bias issues. For example, when the Avena case was pending in 2004, Mexico went in that year from a $0 contribution to a $10,000 contribution. When the interpretation of that judgment was up before the court 4 years later, it went from a $5,000 to a $20,000 contribution. If you think that the court doesn't pay attention to these things, you should consider that Judge Guillaume, when he was president addressing the UN General Assembly, was so concerned about funding for the court that he asked the states not to let the court, quote, die a slow death. Additionally, with respect to the ICJ system, I think that the grant size, the laborious procedure, the jurisdictional bar, and certain aspects regarding the difficulty of monitoring the implementation of funds really calls for a significant overhaul. So in sum, the three paths that I've mentioned, the recourse to institutional funds, the unilateral recourse to third-party sources of funding, as well as the mutual agreement by the parties making use of the dominance of consent in arbitral procedure, is ultimately something which shows variant procedural dynamics applicable to dispute settlement between sovereigns, but also the abiding need to innovate feasible forms of state-to-state dispute settlement in order to preserve international peace and security. I apologize for going over. Thank you.
Thank you very much, Brian. Clearly, you've identified a number of challenges with some of the solutions that have been suggested and attempted with respect to the funding challenges that smaller states face when involved in state-to-state disputes, whether as claimants or as respondents. And certainly an area of international law in which states on the respondent side often find themselves pressed, especially smaller states, is the area of investor-state arbitration, where there are ample sources of funding for claims, both because the parties bringing the claims are commercial enterprises themselves, but also because there is an active industry of third-party funding of claims, which is not generally available to states as respondents.